All right, I think we'll start. I'll start by introducing myself. My name is Jessica Hodge. I'm one of the adjudicators for UQ's witness examination competition. I competed and won the competition back in 2014, and I've been adjudicating it since 2015. So it's been a while. This presentation is intended to be a bit of a how-to seminar for the competition. So I'll run through the way that the competition is structured, the various elements of it, and then give a broad description of the sorts of objections largely that you're looking for in the competition, and then some tips that I have for competing. So to start, I'm not overly good with the actual nitty-gritty how rounds are done, but there is a minimum of 2 rounds, and based on the scores of those rounds, some competitors will break into the quarterfinals, and then it becomes a knockout situation until there's a grand final. There is always a question about how much legal knowledge is actually required to compete in the competition. For what it's worth, I competed after I had done tort and criminal law, but before I'd done evidence law. There are a number of competitors that do compete before they do evidence law, and we've had competitors, including extremely good competitors, who have competed without having done all of tort or crime. So what you need is a sort of functioning understanding of the elements of offences or torts, or a way of figuring that out, and a working understanding of evidence law and objections and what is and isn't admissible. You can certainly make up for the gap in knowledge by some fairly gentle preparation work. A benefit of having competed in the competition is that it does make evidence law a lot easier when you actually do come to do it, because you've already got that base there and you know how it's applied, and you've had the benefit of adjudicators giving feedback about things and the way that they give the practical nature of evidence law. So it's very, very handy for that. For each of the elements of the actual rounds, you have 30 minutes of preparation initially, once the problem is released to you. After that 30 minutes, you then have the opportunity to conference your witness for further 30 minutes, and then the round starts. So each opening statement is 2 minutes, then examination chief is 15 minutes, cross-examination is 15 minutes, then there is a 3-minute break before closing statements. How strictly each adjudicator keeps to those times is up to them. I'm notoriously fairly loose with them. I will get a feeling when an examination or a cross-examination is just going off track, or it's just gone on too long, and that may not necessarily be because it's over 15 minutes, it's just because it's becoming pointless. With the opening and closing statements, the structure that I'll suggest that you use tonight should mean that you will come well under 2 minutes for an opening at least. So the order that that it goes in has been differed in years. So when I started adjudicating, we kept to the order of closing statements in civil cases, also in criminal ones. So where a prosecution gives closing first and then defence, the actual way that it works in court is that if a criminal accused gives or calls evidence, then the defence goes first in closing. Giving or calling evidence means that they have a witness who gives evidence on their behalf, or they do it themselves. It doesn't mean that they have to personally give evidence. So it starts off with the prosecution or plaintiff, depending on whether it's civil or not, opening statement, and then the prosecution or plaintiff's witness. There's evidence in chief, and then cross-examination. There's no allowance in the rules for re-examination, which ordinarily would occur with a proper court case. And then there is a defence opening, the defence's witness, evidence in chief and cross-examination, and then a 3-minute break, and then the closing statements. How to prepare. So I would heavily suggest doing as much preparation for the round as possible before you actually get the problem. That means that you can, there's a lot of, not a lot, but there is some study involved in understanding the rules of evidence. Make sure that all of your material, if you're going to rely on it, is quite accessible. So you've got markers in particular spots. If, say, you want to object to something on the basis of hearsay, you've got that section of the textbook marked. You can also prepare cheat sheets or pro forma templates for certain sections of the competition. I did this when I competed, and it was very helpful. Essentially, if it's an opening, say, you would just have a fill in the blank section with the accused person has been charged under section blank of the blank act with this, and then the Crown must prove its case beyond reasonable doubt. We say that these are the elements, this is the element that we consider is in contention, and here is a summary of what the witness is going to say. That way, you can get as much of that sort of incidental prep work out of the way as soon as possible. You can, to some extent, do it for examination in chief and cross-examination, but it's perhaps, it's not as formulaic. And for conferencing a witness, you can do sort of like a checkbox form, which, yes, I've discussed this, I've discussed this, I've discussed this. So to make sure that you've covered off everything. This is a really key one, which is that you must read the problem as a judge does. There's a bit of a tendency of just getting a witness to recite whatever is in the witness statement, and that's their evidence in chief, and not actually digging into what they are saying. Quite often, and the problem writers will do this deliberately, is that they chuck in words and phrases and things that are perhaps not within the common knowledge of anyone, including the judge, to try and test witnesses, to try and test competitors to actually ask the witness what those things mean, or to explain concepts or whatever. that sort of content isn't in the witness statement, and the witness just has to make it up. That's otherwise it just doesn't work. I adjudicated the ALSA competition last month, and I do remember one specific incident where one of the competitors was, or one of the key facts in this case was that somebody had provided this very expensive bottle of alcohol as a competition prize. I don't drink. I don't understand what it was. And it was just simply referred to as, that we offer up a bottle of crystal for this particular thing. And I turned to the competitor and said, "Can you explain what that is?" And he looked at me sort of like I was deranged and said, "Well, it's a bottle of expensive alcohol, Your Honour." Now, where I grew up, crystal is a methamphetamine. It's not alcohol, but you do need to make sure that those sorts of things are spelled out, because the judge may not, and in the same way that a jury may not, have the sorts of life experiences that a witness has had or an understanding of particular things. In fact, if they are a witness in a criminal matter, you could just about assume that they haven't had the same sort of life experiences. The next is to make notes on topics or subjects that you need to address in cross-examination so that you cover off things. Some people will fully draft cross-examination questions from start to finish. I think it kind of interrupts the flow a little bit just to be sort of staring at a piece of paper and asking a question and then going back to the piece of paper and then asking the next question. It doesn't, it interrupts the flow of the cross-examination. I think it's much easier to just identify something and sort of run with it. And as I said, identify the topics that need further explanation. You can prepare some notes on the way to respond to certain objections. For example, if there is a line in a statement that is potentially hearsay, you can just pull out the explanation that you have for hearsay and go, right, that's what I'm going to argue when I make an objection to the question. When you are formulating cross-examination questions, particularly, slightly less so for examination in chief, but you want to start with, what question am I going to ask in order to get the piece of information that I want? So if you want somebody to say that or admit that they didn't see something occurring, then you say, and you didn't see that occurring. And then you kind of step back from that rather than trying to lead up to it. It's a bit more helpful. That's for preparation purposes. When you're asking a question of witnesses, you start at the beginning, obviously. Conferencing witnesses. This is something that I didn't really appreciate the importance of when I did the competition itself. After 6 years of being a solicitor, it's now something that I appreciate and am finessing, certainly. It is very important that your witness understands what is going to happen and the evidence that you're going to elicit from them and why you're going to do it, because otherwise they just have no clue. Certainly in the practice that or the area that I practice in, witnesses routinely think things that are relevant or things that they think are relevant are irrelevant. And if they are not told that it's irrelevant or the judge doesn't care or whatever, they will take the opportunity of being in the witness box to rabbit on about all of the irrelevant stuff and potentially ruin their own credit in doing so. So whilst it's the case that you can't coach them, that is, you can't tell them the answers to the questions, you can ask them what their answers are going to be. So you ask them what you're intending to ask them in examination in chief. You ask them for any details that are not in the witness statement, or to explain things that you don't understand. If you've got a witness who is sort of like, oh, you know, I'm just a pretend witness, I don't really know what that means, I have no idea, then you kind of sternly break character and tell them to, well, look it up or make up an answer or something, because that's necessary for the purposes of this thing going smoothly. You can tell them what your case theory is, that, you know, this is what I'm alleging happened. You can tell them what the relevant facts are. You can tell them what you're intending to avoid and why you're intending to avoid it. And you can give your opinion, which is really all you can do, because you can't guarantee what your opponent is going to rely on. But you can give your opinion on what you think the other side is going to rely on. The next one is a technique that I picked up from a barrister that I brief, whose name is Josh, as the slide says, about explaining to witnesses how they are to respond to questions in cross-examination. So in a conference, Josh will ask a witness, right, so you see that clock up on the wall? And 9 times out of 10, the witness will respond, yes, it's 10:30 or whatever the time is. And then he says, hang on a minute. That's not the question I asked. I asked, can you see it? The answer to that is yes. You don't need to elaborate. You don't need to provide any further detail. Just answer the question that is given to you directly. The big thing about conferencing witnesses, and I don't know that it occurs because I don't sit in on conferencing in the competition, but you do need to make sure that you don't waste time when you're conferencing them. You are allowed, or you're giving access to your witness for 30 minutes before the hearing itself. You do not need to take that 30 minutes. So if it's the case that after 15 minutes you've covered off everything you want to cover, you're perfectly able to say, look, thanks very much. I'm just going to continue preparing. Could you, I don't know, wait outside of the hearing room or something? I will see you there, and then continue. Again, with in the Ulster competition, it was quite a amusing, I thought, moment, sitting at a table next to one of the competitors who was conferencing his witness. And I was just doing some work before the round started. And he spent about 5 minutes conferencing this witness. He spent about 10 minutes bitching and whining about how shit he thought the problem was, which was quite awkward because I had drafted it, which he wasn't aware of. And then spent the remainder of the 30 minutes just having a social discussion about, I don't know, parties and how terrible her hangover was and whatever else. So in doing that, he voluntarily wasted 25 minutes of his time that he could have spent on either properly conferencing a witness or actually preparing for the case. You don't have a lot of time to do any of it. So don't waste it, you know, being social. You don't have to babysit them. You can just, you know, crack on. Okay, so one thing that will, you'll typically, well, certainly if you're on the prosecution side, but potentially also if you're on the defence side, it will be about the burden of proof. So we all know burden of proof in criminal cases is beyond reasonable doubt. Civil cases on the balance of probabilities. The tricky thing that you need to remember, is where there are defences to things. So self-defense or provocation or whatever. You need to be aware of what the burden is for that particular offence. Oh, sorry, for that particular defence. There, as a general proposition, if you are asserting something, you are required to prove it. This is my formula for opening addresses. As I mentioned before, you've only got 2 minutes, so it doesn't have to be long, or it can't be long, but it does need to be clear, structured, and you need to cover off a variety of things. You don't need to do that in a particularly adversarial style. You're only opening your case, you're not arguing it. So this is the broad structure that I would use for either side. The two main things to avoid, as I've said there, don't let your opening write a check that your evidence can't cash. If it's the case that there is no way on God's green earth that you are going to be able to prove that a client is a liar and a fraud, then don't say that in your opening. Stick it to sort of moderate. The second one is, whilst you do have to open the case and sort of tell a story and lure in the judge a little bit, don't go overboard with the emotive language. So things that really irritate me are things like, oh, there has been a terrible injustice, Your Honour, perpetrated towards my client. And yeah, okay, that's cool. But can we just stick to what we have to prove rather than making it very theatrical? So for prosecution, you start off with just a broad opening line that is more or less something like, the accused has been charged with X under X Act. In terms of the case theory, I will come to that in a second. And then you set out the elements of the offence. You briefly say, we have to prove this offence beyond reasonable doubt. And then you give a 1 or at most 2-line summary of what your witness is going to say. For defence, you start with basically all of the things that you agree to and all of the things that you don't agree to. So if you agree to the way that the prosecution has set out the elements of an offence, then to say, we agree with the elements as stated, this is the one that we say is in contention. Then you state your case theory. If there are any defences, then you provide those and what the burden is for those, and then the same, provide a witness summary. This formula, if you like, is not an original of mine. This is what I was, or what we were told to do back when I competed. And personally, I think it's foolproof. It signposts everything really nicely. It requires you to have a really tight structure in your opening, and it means that you can't traverse into big sort of statements about what, grandiose statements of what you're going to prove. So for your case theory, it is essentially a story about what you say happened, and if the judge accepts it, there's some sort of legal consequence. So if somebody has murdered somebody, the legal consequence is they go to prison. You need to ask yourself, what is it that you have to prove in order to succeed in a case? and what you're going to do, or how you're going to actually do that. It is extremely helpful to know what your case theory is from the outset, and that way you can tailor what evidence and questions and things like that you ask based on that case theory. A defence case theory is more along the lines of, what do I disagree with? So what are the things that you doubt, and how are you going to raise that doubt? There are two broad components, which is sort of clues in the name, but there's a single factual proposition, which is a case, and the theory. So how and why what happened. This is my own drawing of it. So in this case, Mr. Smith murdered Ms. Jones. That is your case, right? That's the charge. The theory is why he did it. It's a very basic example of this. Yours may be slightly, but not too much, more detailed than this. Now, examination in chief. This is, I think, and a number of other advocates also think, so consider how you will, but this is probably the hardest element of this competition or a trial. It's much easier to be a good cross-examiner than it is to be very good at examination in chief. And it's much easier to formulate leading questions than it is non-leading ones. The questions that you ask in examination in chief have to be sufficiently closed, or they have to elicit only a small amount of evidence rather than inviting the witness to rabbit on. Now, you can't ask leading questions in examination in chief unless it's something that's not controversial. So, for example, you're perfectly able to say to a witness, your name is this, yes, and your address is this, yes. That's not controversial. If your opponent does it, don't object to it. It'll just annoy the adjudicator. Now, you need to make sure that you tailor your questions to suit your witness's personality and, unpalatably, perhaps their level of intelligence. Generally, because this is a fairly false environment where you've got a witness who doesn't have any skin in the game, they don't care, this isn't their life, and chances are they're going to be, say, one of your friends, so they might be another law student. They're probably going to be smarter than the average bear. They are not like a normal witness is. Normal witnesses are not necessarily sharp. They don't necessarily provide the answers that you are wanting, or they give the explanation that you ask them to. Sometimes they can misunderstand what you've asked them to say, and some of them just talk more than others. I had a trial, when was it? Back in February, I think, in Rockhampton, where we had a number of witnesses who were farmhands. And with the best will in the world, you could get maybe 2 words and a facial expression out of them in response to even an open question. They just weren't talkers. Whereas I've had other cases where, if left to their own devices, the witness would have just carried on for days. You will get an idea about whether your own witness is like that, and you can inquire. Ordinarily, you can inquire whether the other side's witness is going to be similar to it. because that will become relevant when you're cross-examining them. You also need to make sure, sorry, that hit the wrong button. You also have to make sure that the question that you're asking is clear, and the few words that you use, the better. So I would suggest using short questions, but many of them, rather than long, convoluted questions. The question that I have suggested here, the whereabouts were you seated at that particular point in time, that was a question that was asked in the trial in Rockhampton this year. It should have just been, where are you sitting? That's what you're asking. Don't just put in words to fill the air. There was also quite an entertaining moment in it, where it was a personal injuries case where the plaintiff had been quite badly burnt. And in cross-examination, the first defendant's barrister asked him, and what sort of condition were you in when you were discharged from hospital? And this witness, who was a farmhand, not particularly sharp, sort of looked at him with this kind of puzzled expression on his face and went, burnt? And we all had a bit of a chuckle, including the judge, and went, oh, no, that's actually not quite what I meant. What I meant was, were you in pain? What could you do? How much care did you require? That sort of thing. So you need to be mindful that there are potential other answers to questions. So you have to make it very, very clear. And you need to ask questions about things that the judge may not understand, or in practice, a jury may not understand. Where, particularly if there is a jury, you need to be aware that some may understand, some may not. And if some of them don't, it needs to be explained. For cross-examination, this is the party A's opportunity to be asked question, oh, sorry, it's the witness for party A's opportunity, or opportunity to answer questions of party B in order to reduce their credibility or obtain evidence which is favourable to party B's case. It is important to keep in mind that you can do either of those things. Cross-examination is not exclusively to ruin someone's credibility. They may well give you an answer to a question which is quite helpful for you. Now, in this instance, you may ask leading questions. You don't necessarily have to ask leading questions. The question that I mentioned earlier with the response of burnt, you would have noted is not a leading question. In that case, it probably wasn't one that was particularly risky because of the nature of the witness. He just wasn't going to ramble on anyway. So just make sure that you know what kind of answer you're going to get, irrespective of whether you ask an open or closed question. In terms of your style, you should be at worst assertive. It is not an opportunity to get aggressive. It is not effective to be aggressive. The best cross-examinations I've seen have been just sweet, nice, lovely, friendly conversations between the barrister and the witness. And some of the worst I've seen have been ones that just abuse has been hurled at them. If you are nice to a witness, they are more likely to help you. That's true of anything. And it also means they kind of let their guard down a little bit because they would have been prepared for you to be a jerk. And if you're not, you're kind of a bit, it's sort of the rug gets pulled out from under them. If a witness becomes aggressive with you, then that's where the assertive comes in. So that's where no, thank you, Mr. Smith. I appreciate what you're saying. However, can you please answer my question for the 14th time? It is not an opportunity to be reenacting scenes from A Few Good Men, notwithstanding what some people think. If you become aggressive with witnesses or unnecessarily aggressive with witnesses in a proper court, you might well be told off by the judge, and it won't be pretty. And it'll be in front of your client, which is embarrassing, and in front of the opposition, which is also embarrassing. You can probably get away with being a bit more aggressive with an ordinary witness than you can with, say, an expert. In expert situations, it is very sort of cold, clinical, professional. But notwithstanding that, don't ever get aggressive with them. Probably one of the best cross-examinations I've seen, the counsel was bordering on really flirty with a witness, and she ruined her employer's case in about 20 minutes of cross-examination, conceding to all of these things that were unhelpful for them. And he's making little jokes with her, and she's very dynamic and personable and lovely. And there's just this kind of nice little relationship going on between the two of them. They're joking and things, and she's just answering these questions in a very, very favourable manner. And between leaving that hearing, which was I think the first day of the hearing, so it was continuing, between leaving that hearing and getting back to the office, we had received a settlement offer. So it's very, very helpful to be nice to them. You must also comply with Brown and Dunn, which I will come to in the next slide. So this is a rule which requires you to put very deliberately, squarely, clearly to the opposition's witness what your case is. It is an opportunity for them to agree or disagree with what's been said. When you're conferencing your witness, it can also be very helpful to explain this rule to them. You don't need to necessarily say there is a rule in a case called Brown and Dunn, and this is what you have to do. You can just say you will be asked questions that would seem bizarre, and that you would think that the person asking them should know the answer to them. They're not expecting you to say yes, but they have to do that in order to make a particular case or to make particular arguments. This is an area where I have seen that there's quite a lot of duplicitous questions asked, or very convoluted questions, where somebody will, as one question rather than multiple, just rattle off their entire case theory from start to finish. You shouldn't do that because it's potentially something that can be objected to. Just step through it. So I put it to you that you took out a knife, yes or no? Yes. And that you stabbed this particular person, yes or no? And that you did that because you wanted her money or whatever the reason is. If you don't do it, the options in practice are that a witness can be recalled. That won't happen here. If it's a jury, the judge may direct the jury to disregard any contradictory evidence adduced in cross-examination. That's a last resort for criminal cases, but there could potentially be a judicial direction to draw an adverse inference or that you will not be able to make final submissions on a particular issue. It's really the last one that is what might happen in this competition. I suppose I've never really stopped someone from doing it, but it is a scoring thing very much. And as I mentioned before, you need to very clearly and deliberately put the things to the witness. For objections, the big one or big problem with objecting in usually the first couple of rounds of the competition is that people just sort of sit there and say, I object, Your Honour. If you want to object, you have to stand up. Or if you want to talk in any way, you have to stand up. And then your competitor or the other side will sit down. So there's only one person ever standing at any point in time. If you are wanting to make an objection, you can use the time between, or the time it takes for you to stand up to your advantage. I was a witness for the bar practice course, well, I have been for a number of years, but on one particular occasion, one of the barristers who was coaching the pupils said that you would notice that with some of the older QCs, they take quite a long period of time to stand up. Maybe it's age, but in doing that, they do give themselves a couple of extra seconds to sort of formulate what it is they're going to say. If you're wanting to make an objection, you stand up and then you say, I object to this, Your Honour, and provide your reason why. You don't say, I object, and then stand up. The common ones are if there's leading questions in evidence in chief. Note that if somebody has asked a witness, could you please describe what something means, or could you explain what happened there to the judge? Yes, technically that is a leading question because the witness can say, yes, I can, but don't object to it because it'll just annoy people. That's more of a style thing. It's not something that you ever object to in practice. You object to questions which might lead to a witness giving inadmissible or irrelevant evidence. That's the key. You need to object to the question. Once the witness has said all of the stuff that's inadmissible, it's in evidence. And the jury's heard it, they can't unhear it. You can object to convoluted or duplicitous questions. So where there's multiple propositions put to a witness in one question, you object to that. If something is just cannot be understood, then object to that. And if your opponent is really hounding your witness, asking the same question, which has been answered over and over again, then you can object to that. There tends to be, or there is a tendency to object the second time an advocate or a barrister asks the same question. I don't allow those. It's really only after about maybe the fourth or fifth time that we're just going nowhere, that really you can say, look, Your Honour, we've traversed this repeatedly. Can we move on? Okay. So the first kind of objection that you can make, or the first point of evidence law at least, is in relation to something's relevance. So the admissibility of evidence will only be considered if it is relevant. So in order to even get it in there, it has to be relevant, and then the court will consider whether it's admissible. And after considering whether it's admissible, they will then decide whether or not there's actually any probative value to it. So evidence is relevant, and this is the Goldsmith and Sandilands classic thing, that if it could rationally affect, directly or indirectly, the assessment of the probability of the existence of a fact in issue in the proceedings. The issues in the court could be in relation to primary facts, which are facts that a particular party must prove to succeed, or secondary issues, which govern the admissibility or weight to be attached to the primary facts. So for a primary fact case, an example in a rape case would be whether or not somebody consented. A secondary issue would be whether or not the victim had a motive for accusing the accused of rape or something similar. Inadmissible evidence is evidence which falls foul of a rule designed to exclude evidence on the basis that it is unreliable, potentially misleading, or contrary to public policy. It is important to remember this just governing principle because it will help you understand what the way that evidence rules operate. If you appreciate that what we are trying to do is to get the best possible evidence into the proceeding and keep out all of the garbage that is meaningless, then it makes more sense as to why things like hearsay are inadmissible, because it could potentially be made up, or it could be misunderstood, or it just doesn't have any probative value and could just lead the jury usually, or potentially the judge, off in a direction that is unnecessary. Now, evidence can be admissible for one purpose but not another. Hearsay is a classic example of that. Now, this is a potential, quite a big bugbear of mine. I listen to a lot of true crime podcasts, and quite often the presenters of them will describe evidence as being entirely circumstantial, either stuff that has been presented to prove that an accused didn't commit an offence, or if somebody's been wrongly convicted, something to prove that they did the offence. Just because something is circumstantial doesn't mean it's crap. There are quite a lot of examples of direct evidence which are very unreliable. So I would steer away from using the tagline, all of this evidence is circumstantial, as a way to, or as a form of advocacy. Direct evidence is evidence which is even from a person that directly proves a fact in issue. So, for example, it's evidence from a person who saw the accused stabbed the deceased. Circumstantial evidence is indirect evidence of a fact in issue. So if a person saw somebody running from the scene of a crime, that's circumstantial. As I said, circumstantial evidence is not a poor man's direct evidence. I would much prefer DNA evidence over the evidence of a blind and deaf 92-year-old who saw somebody that they think potentially might have been the accused, possibly from 100 metres away in the dead of night, committing an offence. It doesn't necessarily mean that it's got any additional value if it's direct. There are plenty of cases which are decided almost exclusively on circumstantial evidence. provided that the accused's guilt is the only rational inference that can be drawn from the circumstantial evidence. I have given examples which I've taken in order not to breach copyright from my camera roll to demonstrate what is direct and what is circumstantial evidence. So this is an example of direct evidence, made up charge under a made up act. And that is on the 12th of August 2021 in Grange in the state of Queensland. Rigby Dingleberry Hodge, my dog, did indecently display his lipstick in breach of Section 101 of the Good Boy Act. Now, putting to one side the fact that the photograph might not necessarily be direct evidence, if you have got a witness describing that, that is direct evidence, because that is the charge, or sorry, that is the incident occurring. This is an example of circumstantial evidence, again, with Rigby, that he did unlawfully damage a cushion in breach of Section 52 of the Fluffy Cushions Care and Protection Act. It is not evidence of him actually ripping the cushion apart, although the fact that he's got little feathers on his face and all over his torso would suggest that it would be good circumstantial evidence, put it that way. All right, the next one is character evidence. Again, I've got Rigby as my model. Now, character evidence can be evidence about a person's reputation in the community, their track record, either good or bad, or their credibility as a witness of truth. And I appreciate this is an expert situation, but if, for example, you had a doctor giving evidence and you were going to provide, or you were wanting to elicit evidence about how fantastic they are and how many people they've saved and that nothing has ever gone wrong, that could be evidence that goes to their character. It is not the same thing as credit. Credit is more removed, it's more distant. Somebody can have a fantastic character with zero credit. Credit is more of a critical analysis of what they've actually said and whether or not it accurately represents reality, rather than whether they're a good or bad person. It is relevant only to the reliability of their evidence. So the gist of which is somebody who has a terrible character is more likely to be a liar, arguably. Now, an accused person can, if they wish to, lead evidence of their good reputation to argue that it is less likely that they committed an offence, or to support their credibility as a witness. However, if they do it, the prosecution has a right to then lead evidence about everything they've ever done wrong. So it is always done with caution. The way I generally refer, or the way people generally refer to it, is somebody has put their credit, or sorry, put their character in issue. It will be something that will be raised in a number of witness statements in a number of problems. And it's there deliberately so that you avoid it. In terms of the character of a criminal accused giving evidence, they can't claim privilege against self-incrimination in respect of matters which they are on trial for. So, for example, if they've chosen to give evidence in a murder trial and they're asked questions about whether or not they committed the murder, they can't just turn around and go, well, that's incriminating. Well, you've decided to sit in the witness box, you will be asked questions about whether or not you did it. That's the idea. They can be shielded from questions that are intended to reveal any of their past misdeeds, unless there is some exception that applies, which I'll come to in the next slide. If their evidence is admissible, it's only admissible for under the exception, then it's only relevant to their credibility. Even though the good character evidence may have elicited remains relevant to both their credibility and their guilt. So the next big one, which does come up in problems, is propensity evidence. Now, if we were taking Rigby as an example, and he was on trial for beheading a toy pig, then potentially you could elicit evidence of all of the toy pigs that he has beheaded in the past. You would, in order to do that, you would need to argue that those past offences are sufficiently similar to what he's on trial for. The idea of it is to demonstrate that a person has a particular propensity to behave in a particular way, and therefore it's more likely that they have committed the offence in this particular case. It's very relevant, but it's also very prejudicial, so courts will balance the two of those. And the classic Fenig test is that it can only be admitted, it's admitted when taken together with other Crown evidence, there no longer remains a rational view of the evidence which is consistent with the innocence of the accused. So that is, there is no possible way that anyone else could have done this. If you are trying to drag in things that have happened before, you also need to prove those beyond reasonable doubt. There can't just be a sort of a passing reference to them. If somebody has been previously charged with similar offences, that's a bit easier because that's been proved in a previous case. But if they're uncharged acts, that's very different. You're effectively putting somebody on trial for all of those previous acts as well. One thing that I will note, because I've had this come up in practice a fair bit, is that this is the standard that applies to criminal cases. Civil cases, it's not as high. It's more of the relevance test. You don't have to prove that very close link between the two. This, again, comes up frequently, is hearsay. So it is one of the, or what I've found at least, is one of the more difficult for people, not just competitors, to wrap their head around. It is a description of something experienced by person A, given to a court through the testimony of person B. So that is that person B is giving the court evidence of what person A saw, believed, etc. And the reason why it's unreliable is because the actual person who experienced those things, who saw, heard, etc., can't be cross-examined. So you can't test their evidence. It may be the case that they were misguided, or that they didn't in fact see something, or they got their dates wrong, or the descriptions are all over the place. And it may be that person B has just misinterpreted what person A has said, or has, certain things have been implied, and person B has filled in the gaps, etc. So that's why it's not helpful, and that's why it's not admissible. It covers express statements, implied statements, assertions by conduct, and documents, although the document part is not relevant in this particular competition. It is only hearsay if it is being used to prove the truth of its content. It's not hearsay if it's being used to prove that the statement was made. So if somebody is giving evidence that they heard a person talking on the phone and saying, I did this particular thing, it is evidence that that person has told another one on the phone that that's what they did, which is potentially relevant for prior consistent or inconsistent statements purposes. It is not evidence that they actually committed the offence. So the example that I've given is that person A tells person B that he saw person C throw a big brick through a window. It's not admissible evidence that person C did throw that brick, but it's admissible to prove that person B said that he saw person C do it. There are exceptions, as with everything. The two common ones are res geste and dying declarations. The res geste exception is that the particular statement which is considered hearsay was made under the influence of the event to which it's related. So the person who said it had no opportunity to consider making something else up. The spontaneity of the particular statement is relevant. So if, for example, an accused person says, oh, I can't believe I just stabbed him, or I can't believe what I just did, a couple of minutes after stabbing somebody, then that could potentially be res geste, because in the time between the offence occurring and the actual statement being made, he had no opportunity to come up with some sort of fabrication. They've had no opportunity to reflect on it. You do have to note that there is an exception to that in 93B of the Evidence Act, but I won't go into great detail of it. The next is contemporaneous statements of thoughts or feelings. So if somebody after they're assaulted goes, ow, or they say that they feel unwell or that sort of thing, that can be admissible to prove that the witness had those thoughts, feelings at the time in which it was made. So if they've said ow, it's evidence that they were in pain. There's informal admissions. So prior statements made by a party that are adverse to their interest, maybe. There's confessions of ultimate facts and dying declarations. Or statements of deceased witnesses. There are another couple of exceptions, but not really things that we address in these cases, particularly in relation to the duty or legal duty that a deceased owed somebody, which they've confessed to. But dying declarations are things that are said when a person has a settled, hopeless expectation of death. Typically, it's something that they've just uttered between, I don't know, being stabbed and dying, but it doesn't necessarily need to be. It can just be at any point before once they have got that settled, hopeless expectation. If they make any sorts of statements, then that's potentially an exception. I'll just briefly touch on expert opinions, not because you will get to examine or cross-examine any expert witnesses here. It's more that if you come across something in a problem which really should have been given by an expert, that is something that you could potentially object to. Witnesses can only give evidence of facts. They can't give their opinion. There is an exception made for experts. And the Makita and Sproul set of criteria is the ones that are used to ascertain whether or not a particular person is or isn't an expert. So if there's a recognised field of study, so psychiatry is probably a good example, orthopedic surgery is a good example, but something like, I don't know, telekinesis is probably not a good example. Something really esoteric and weird. And that by virtue of somebody's education, training, experience, they've proved that they are indeed an expert in a particular area. They can't also come to a conclusion about ultimate issues. The ultimate issue point is that is relevant in Queensland under the Evidence Act and in common law. It is not the case for the Commonwealth Evidence Act. There they can come up with, or they can give evidence of ultimate issues. Ultimate issue, an example of an ultimate issue is, say if it's a negligence case, an expert can't say this particular person breached their duty of care. That's not a question for them, that's a question for the judge. Some classic examples in problems that you would encounter that do require an expert would be somebody using, colloquially usually, a mental health diagnosis and adjective. So say describing somebody as, oh, it's like she's bipolar, or she's a bit OCD, that sort of thing. That is distinct from if they describe somebody as, or somebody's presentation is depressed or anxious. They're not necessarily attributing a diagnosis to it, they're just describing mannerisms. If you had a witness who was going to give that evidence, you really should flesh out what they mean by depressed or anxious. If you've got a witness who was going to say it's like somebody's bipolar, tell them that is not appropriate and get them to describe what it is that they meant. The next one is witnesses who make sweeping generalizations about population behaviour. So things like, well, no one would ever do this, or everyone knew what this meant. Very common. They've got no way of knowing what everyone knew. They have no data on it. It's really more of an expert point, arguably. So these are my tips and tricks for things. So the witness statements that you're given are not in evidence. They cannot be tendered in evidence. This is a point that pisses off a lot of people, competitors, that is. The reason why you're not allowed to do it is because the idea of the competition is that you elicit all of the things on the page. It's cheating if you just hand it up, right? Now, I appreciate that people will say, well, in practice, statements are tendered. That's not necessarily the case, but it's, and certainly not in criminal matters. So just, that's what you have to do, tough luck. The next is that just because your case is rubbish doesn't mean you're going to lose. There are many occasions where a terrible case where somebody's would be convicted or somebody would typically have failed to prove breach of duty of care or whatever, will still win a round. It's about how you go about it. If you make a a great case, or as best a case you can, with what you've got, that's enough. This is my bugbear, which is don't let your stationary choice be your Achilles heel. I am very easily distracted. If you are a pen clicker, you need to get a non-clicky pen. I can't put it any higher than that. I have, because I'm a real pain in the ass as an instructing solicitor, I have been known to confiscate pens from barristers if I consider they have been excessively clicking it. I give them a non-clicky pen in response, and then they will get their clicky pen back when they can prove that they can click the pen responsibly. For a similar reason, if you want to use your laptop, fine, but I'm not going to like it, and it's going to distract me, and it's probably going to lose your points. I don't know that every adjudicator is going to be like that. There is nothing more annoying in court or in telephone directions hearings or whatever than to hear constant tapping on a keyboard. Just use a pen. It's, I don't know, archaic, but silent at least. Further to me, describing how much of an annoyance I am, I'm a bit sort of pedantic about what I use and how I use it. This is some stuff that I have removed from the Ziploc bag of trial gear that I take to everything. So I usually take 3 different sizes of Post-it notes. Usually the bigger ones are for notes that I pass to counsel during the hearing, but that is good if you've got big handwriting, or you've got a fairly lengthy point that you want to note to yourself. The smaller ones are probably more for flagging documents or flagging sections of textbooks or whatever. In the competitions, I'd suggest 3 different coloured pens. One of them's for general submissions or preparation things you're going to write, and then the other 2 separate colours for witnesses. That way you can you can note things on the witness statement that was said by each of them, and you know after the fact who has said what. That's why I use different coloured pens. The same goes for highlighters. I've got 3 different colours, 1 for just general noting things, and then 2 for the 2 witnesses, and flags as well if required. That's probably more, or it's more helpful when I've got a court book that I flag for sections of it that witnesses have been taken to in examination in chief and cross-examination. Certainly in witness statements, there won't be a hell of a lot that you need to flag. This is more of a bonus one, and I don't know where exactly you would get them from, except for somewhere on the internet, but the bottom thing that lot of Post-it notes are transparent ones, so that you can stick them over books that you borrowed from the library or from friends or whatever, and you can make notes over the top of that and highlight it without actually doing any damage to the book. All right, so this is my very long list of things that I think are potentially helpful, and I've kind of graded it in 3 different levels. The basic overviews of the Commonwealth legislation and Queensland for the David Field classic textbook, which I assume is still used for evidence law at UQ. And then there's an evidence law guidebook, which is sort of like a brief annotated legislation The next one are fantastic. These are LexisNexis produces quick reference cards for various different topics. So they've got one for evidence for common law states. They've got another one for evidence for uniform evidence law states. They've got ones for crime, tort, insolvency, civil procedure, all sorts. And it's a fold out card, laminated card, with summaries of particular points on it. If you're wanting a more advanced overview, there's Forbes, Evidence Law in Queensland, and then Hayden's Cross on Evidence. The Cross one is the much more detailed analysis, and it obviously includes the Commonwealth legislation as well. You probably won't need anything that detailed, or for Cross, if you're looking at Cross, for the actual competition, but Evidence Law in Queensland is still quite helpful. The next lot is a selection of just things that I think are generally helpful to read if you're wanting to get ideas about advocacy. There is the Mildren book and the Howard book on Aaron Murdoch and Aaron Malat are obviously key cases that have happened in Australia. The Malat one deals largely with the cross-examination of Ivan Malat, which took place over 4 days. The style of the particular barrister who cross-examined him is probably not for everyone. He's a somewhat controversial figure. If anybody followed the Kelly Lane saga. And the Murdoch book is really about identification evidence and circumstantial evidence. They're more, I won't say fun bedtime reading, but they are for interest sake. The Reynolds Leading Cases in Australian Law is basically a 2-page summary of the 200 most cited cases in Australia. Some of those are evidence, some of them are civil. Then Brown and Dunn will be one of those, Makita and Sprouse will be one of those. It gives you a nice tight summary of those particular cases. David Field's Crimes That Shape the Law, it focuses on particular cases that are relevant for evidence purposes, like Weisensteiner, and a particular section of it is on the Andrew Mallard and Graham Stafford convictions and the way that evidence was analysed in those, which is very interesting. I found particularly the Graham Stafford one because I grew up not that far away from where Leanne Holland was killed. So it's a sort of interesting case of mine. Okay. If you are wanting to find out more information, you can read the competition rules. There's the competition handbook. You can watch videos on YouTube. You will see good, bad, and indifferent ones. Similarly, if you go to trials, I would suggest that if you're going to you want to actually see some sort of the evidence going as it happens. You again will see absolute rubbish, and that's okay. You are able to then look at that and sort of critically analyse how it is that you would have done it or how it should have been better. And then there's UQLS's groups and speaking to the competitions team. On the whole, if you are on the fence about whether or not to compete in this competition, I would say yes. It's extremely helpful both to get you an idea of how trials work. If you're the sort of person who is not really interested in practicing in litigation, firstly, I think you're very boring, because that's really the fun part of law, but it gives you a very tight practice run about how things will go in the real world, without actually having any consequences to things. So no one goes to jail, no one gets a cost order made against them. It's all just practice. I look back on things that I argued when I was competing and wonder what I was on at the time. That's what you do. You consider it and you move on. It will also help if you do it before you do evidence law, because then you've got at least a basic understanding. You're not starting from square one. And it's very good for advocacy purposes, because you do have to think on your feet. I mooted quite a lot as well when I was at UQ, and I will controversially say that I prefer the witness examination competition. Yeah, so does anyone have any questions about particular points I've raised or anything?